However, the average person in that trauma would have given up. And this is one beauty of how we operate so the people are free to file it themselves. And we kind of warn them that if it gets dismissed, you have to wait an entire year to file again. I've
Mm.
sat in court where a young lady failed to check the box saying that she had not filed for an expungement before. But because the judge was merciful, she continued it so she could amend her petition, even though the state wanted it to be dismissed based on faulty paperwork. The statute was eligible, but the fact that she hadn't checked that one box was going to make her have to wait a year. So this was a very humanistic judge, and at her discretion,
Yeah.
she continued it. So you back to your question. Why would people want to oppose it? In another petition hearing, the prosecutor had not had a chance to look at the petition, so they continued it. So the second time, she objected and wanted to continue because she hadn't read the answer to her reason for dismissal. And the fourth time we went, she finally sent a memo the day before court saying she had no objection. So a lot of it is their caseload. They're not reading the files, and I guess in an integrity, they're acknowledging that to the judge that they hadn't read it, and consequently, we were able to prevail. However, the average person in that trauma would have given up. She was charged with child abuse. They got pleaded down to endangering a child 38 years ago, where her son being rebellious, she grabbed his arm and left like a little mark in the hotline 38 years ago. And so the prosecutor was like, I don't think you qualified when she did. And she ultimately got the expungement.